Well, as folks are starting to roll in, I want to say thank you all for attending our Centering the Margins panel, Sex Discrimination Knows No Bounds, a discussion on the importance of legal support in honor of Sexual Assault Awareness Month. My name is Kinyora Parham, and I am the director of End Rape on Campus, and our mission aims to end campus sexual violence by providing direct support services for survivors in their communities, prevention through education, and policy reform on the campus, local, state, and federal levels. Centering the Margins is our framework under which all of our programs and initiatives focus, amplify, and support historically marginalized and underserved student survivors in the campus anti-sexual violence movement. For today's topic, we have some very special guests with us, lawyers and advocates who are committed to the fight for gender justice, gender-based violence, and as well as tackling issues for student survivors at the intersections of their identities. So whether a student identifies as a student of color, a member of the LGBTQ plus community, maybe an immigrant student, a student with a disability, a student who may come from a low-income background, regardless of your identity, these individuals are central to driving change in the court system and in our society. Before I introduce our panelists, I would like to inform you that this webinar is being recorded. Attendees do not have the ability to share their screen, but you will have the ability to interact through our chat, whether you're on Facebook Live or hanging out with us on Zoom. Please feel free to ask any questions throughout this webinar, and if we have any time in the end, we will definitely be sure to answer those questions. I also want to apologize in advance for anyone who's joining us on Facebook Live as I'm toggling between two screens. And so if we miss any of your questions, we'll be sure to follow up with you via email if we do miss any. In this discussion, we'll be asking a series of questions to our panelists, along with some real life scenarios where our guests will provide some insight on what you should know with respect to your rights, processes, and possible outcomes. I do want to provide some trigger warnings ahead of time in that we will be discussing content that includes rape, sexual assault, sexual violence, and other forms of trauma. So please feel free to step away from the screen and give yourself time to process and breathe. And for anyone who needs any immediate resources, I'm going to drop these in the chat here, and just, again, feel free to step away from the screen and give yourself some time. Without further ado, our first panelist is Brenda Starr Adams, and Brenda Starr Adams' pronouns are she, her, hers. Brenda is an attorney of Equal Rights Advocates, a nonprofit organization dedicated to the expansion of educational and employment opportunities for women X and gender expansive girls. Brenda leads ERA's impact litigation, fighting gender discrimination at work and at school through cases that address systemic issues like the exclusion of victims from court processes related to their Title IX cases, discrimination provisions of DeVos's current Title IX rule, or predatory practices against people like immigrant janitorial workers. Brenda also oversees ERA's direct service programs, which provide advice, information, and limited scope representation to students and employees across the country facing gender discrimination. Prior to joining ERA, Brenda spent 7 years representing survivors of domestic violence and sexual assault in family law and immigration cases. And prior to that, Brenda spent 4 years representing low-income tenants facing eviction in the East Bay. Next, we have Elizabeth Tang, and Elizabeth's pronouns are she, her, hers. Elizabeth is an education civil rights attorney at the National Women's Law Center, where she focuses on ending sexual harassment in schools through Know Your Rights education for students and families, policy advocacy in the federal, state, and school district levels, and litigation on behalf of student survivors against their schools and against the former Trump administration. Before joining NWLC, she interned at the American Civil Liberties Union and the US Senate and worked at APNE Women's Collective in Mumbai, India. Elizabeth holds a JD MBA from the University of Pennsylvania and a BA in economics from Harvard. Following Elizabeth is Harjeet Kaur, and Harjeet's pronouns are she, her, hers. After joining ERA in 2018, Harjeet leads ERA's initiatives to end sexual violence in education, aka ENOUGH, to close the access to justice gap for students facing sexual assault and other forms of gender-based violence in schools and universities. Harjeet manages a network of trained pro bono attorneys to provide critically needed legal assistance and advocacy, providing students with access to high quality, confidential, independent legal support and assistance. Harjeet joined ERA with over 7 years of professional community advocacy and organizing experience as a civil rights, human rights, immigration, and family law attorney. She has deep experience providing extensive pro bono legal services to victims of domestic violence in immigration and family law proceedings. And last, but certainly not least, we have Shwali Patel, and Shwali's pronouns are she, her, hers. Shwali Patel is the Director of Justice for Student Survivors and Senior Counsel at the National Women's Law Center and leads the center's advocacy addressing sexual assault and harassment in schools. Previously, she was at the U.S. Department of Education Office for Civil Rights, or OCR, where she worked on civil rights policy and legal guidance interpreting Title IX's anti-discrimination protections, including schools' responsibilities in responding to sexual harassment, protections for transgender students, and the rights of girls of color. Before joining OCR, Shwali was an administrative judge and an investigator at the U.S. Department of Energy, Office of Hearings and Appeals, a special assistant United States attorney in the District of Columbia in the Sex Offensive and Domestic Violence Unit, and a law clerk to the Honorable Laura A. Cordero at the Superior Court for the District of Columbia. She also served as the board president of the Asian Pacific Islander Domestic Violence Resource Project, DVRP, and was a community educator at the District of Columbia Rape Crisis Center. Therefore, I want to welcome everyone to the panel and such impressive resumes behind you. So I am in such great company. So let's get started. So my first question to you all is really to provide some clarification for those of folks who are joining us, especially, as we're trying to navigate through this Title IX process. We hear a lot of terms that come up that, need a little bit more clarification. So Elizabeth, I'd love to start with you. Can you provide some clarification between the difference between preponderance and clear and convincing?
Sure, thanks, Kenyora. So the preponderance standard and the clear and convincing standard are both different types of standards of proof that describe how much evidence you need to prove that there was misconduct. And courts and other types of decision-making authorities use a lot of different types of standards of proof. So before we talk about those two, I want to just explain other types. There's reasonable suspicion, which is probably the lowest standard. That's what's required for a traffic stop. There's probable cause, which is a little bit higher. That is what's required for a search. And then you have preponderance of the evidence standard. This means more likely than not. So that means just over 50%. Preponderance of the evidence is a standard that's used in all civil rights cases when you're talking about sex discrimination, race discrimination, disability discrimination, etc. And it's also used in all types of civil cases. For example, if you have a breach of contract claim or if you have a claim for wrongful death. So in all of these cases, what you're trying to figure out is whether there is more evidence than not that the misconduct happened. Clear and convincing evidence standard is higher than preponderance of the evidence. What that means is highly and substantially more likely than not. And this is used when there are very high stakes. So for example, in a deportation proceeding, or if you're trying to figure out if someone should be committed civilly. So again, this is a little bit of a higher standard and it's not appropriate for civil rights cases or in civil cases generally. And then the highest standard that folks are probably familiar with is beyond a reasonable doubt. And that's what's used in criminal cases. So if prison is a possible outcome, then you'll use that standard because there are very high stakes involved for the defendant. And again, this is for criminal cases, not for civil or civil rights cases. And so when you're talking about Title IX, which is a civil rights law, the appropriate standard to use to figure out if there was sexual harassment or sexual assault is the preponderance of the evidence standard.
Absolutely. Thank you so much, Elizabeth, for that breakdown. Shwali, if you can give us a little bit more clarification between the differences of sexual harassment versus sexual assault.
Hi, Kenyora. Thank you so much for having me join this very amazing panel with such distinguished speakers and colleagues. So really grateful to be here with you all. And so I know it can be confusing, when you think of like how Title IX refers to sexual harassment, but it's important to know that sexual harassment under Title IX, which is this, anti-sex discrimination law that prohibits sex discrimination in educational programs and activities, including sexual harassment, that sexual harassment includes a range of sexual harms. It includes verbal harassment, harassment via the use of images, as well as sexual violence and sexual assault. I know for many who are not attorneys or civil rights attorneys working closely on like Title IX or other civil rights anti-sex discrimination laws, it might seem kind of backwards for sexual harassment to be inclusive of sexual violence and sexual assault, but that's how it is in our civil rights laws. It's also like that under Title VII, which is the anti-discrimination law, prohibits discrimination in workplaces, including discrimination based on sex. And Title VII, like Title IX, has requirements for workplaces when it comes to sexual harassment. So if an employee is sexually harassed, including sexually assaulted, there are certain steps that workplaces need to take. Similarly, under Title IX, if a student or a school employee is sexually harassed, including verbal sexual harassment or sexual assault, other forms of sexual violence, then there are certain steps that their school needs to take. So hopefully that's clear, but that is the main difference. And again, this is because of the way our civil rights laws address and define sexual harassment and other forms of sexual harm.
Thank you so much, Wally. And Brenda, for you, if you can just give us a breakdown of Title IX investigation versus civil versus criminal, because a lot of folks get confused, especially when we're thinking about the other terms that we just broke down for folks.
Yeah, absolutely. And thank you all for having me. It's wonderful to be here. It can be really confusing, so I'm happy to explain it. So first of all, the Title IX investigation that some of you may have experienced yourselves is what's called an administrative procedure. It does not involve the court. There's lots of different types of administrative procedures, and this is one of them. So it's an investigation and an adjudication. In other words, the school is making a determination, it's weighing evidence, it's figuring out what happened, but it's doing all of that outside of the court. Sometimes it might feel like you're in a court because of all the new procedures that we are having to deal with, but it's not. And there's big differences. So the rights and obligations that you all have and that the school has under Title IX for the investigation are, basically set by the school's policies, excuse me, and by, state and federal guidance. Civil cases are basically any case essentially that is in a civil court. And that could be a variety of things. So in this context, it might be you feel that the school mishandled your Title IX case, and so you are now suing the school for money damages, meaning you're seeking money from them because they failed to follow through with their Title IX obligations. That's a civil lawsuit. You could also sue your abuser under something called the Ralph Act, and that's a law that allows you to sue your abuser for money, again, for what they've done to you. You might also seek a restraining order in court. That is through a civil process. There's various types that you can get. And Elizabeth was talking about the burdens of proof earlier. For a domestic violence restraining order, for example, you would have the same burden of proof, preponderance of the evidence. If you are trying to get a civil harassment restraining order here in California, it's actually a higher standard, something we're actually trying to work on fixing. So then separate from that, and as in a civil case, you have all the rights that a party would have, right? You're the plaintiff in the case. Or you might be familiar with defamation cases. Those are other types of civil cases where the victim is actually the defendant in the case in many cases. And then you have criminal cases, right? And the criminal case is distinguished by criminal penalties. If you lose a criminal case, you can face jail time or even harsher penalties. And so that's what distinguishes it. Like Elizabeth said, that's going to be a reasonable, beyond reasonable, what am I trying to say?
Reasonable doubt.
Why can't I think of it? Thank you. So thank you. Reasonable doubt is like the easiest standard ever to remember. Everyone's watched Law and Order. And so what's important to note, I think, for criminal cases is something, I just think that a lot of survivors and victims don't understand the criminal process, and it's a very different process. As the victim, unfortunately, you're not a party to that case. So you really have very little control over what's going on. There is a law that gives victims specific rights called Marsy's Law, and it outlines what those rights are, and you're supposed to have a victim's advocate that carries you through the process, and you need to be informed, et cetera. But you don't really have much say, if any, over what happens, over whether the police actually send your report to the district attorney's office for filing charges, whether the district attorney then chooses to file charges, whether they choose to go through with the trial as opposed to like settle the case out. So you don't have much say in that case. It's a very different process. And you basically get different things out of each of these processes.
That is so good to know. Thank you so much, Brenda, Elizabeth, and Shwali for providing these breakdowns of these terms. And, we're talking about Title IX, and there may be folks who are like, what is Title IX? What are they talking about? And just to give a very brief definition of what Title IX is, Title IX of the Education Amendments Act of 1972 essentially states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. So with this in mind, what does centering the margins mean to you? And how do you incorporate this into your work, especially when we're talking about Title IX, which really focuses on gender discrimination specifically? And Elizabeth, we can start with you.
Sure. And is this better? My volume, I try to sit a little bit closer to the screen.
Oh, no, you're good.
Great. So at the National Women's Law Center, one of our priorities is centering women and girls of color, and also queer and trans people, which includes non-binary students as well as disabled students. And one of the reasons why we do this is because race and disability are often seen as male, which is kind of similar to the way that gender is often seen as white. And so this sort of exclusionary thinking can often leave out students who have multiple marginalized identities. And when it comes to sexual harassment, women of color and girls of color, particularly Black women and girls, are often more likely to experience sexual harassment and assault, and also more likely to be ignored or to be punished actually when they come ask for help. So for example, Black and brown women are more likely to be seen as promiscuous, to be labeled as aggressive, which makes it more likely that when they come forward, school officials actually blame them for their own rape or their own assault, or they might discipline them for making what the school thinks is a false accusation of sexual assault. And similarly, with LGBTQ students, pregnant or parenting students, and disabled students, these groups of students are also more likely to be sexually harassed and assaulted, and more likely to be disbelieved or punished. And again, there's pernicious stereotypes that come into play for each of these student groups or these populations. And for example, queer and trans students are often seen as attention seeking in the way that they live their lives. And that can be a reason why schools will blame them for being sexually assaulted, because if you weren't so gay or so trans, then maybe you wouldn't be a target for that harassment or assault. For pregnant or parenting students, they have proof that they've engaged in sexual activity before in the form of the pregnancy. And so people can sometimes see this as a reason to harass them or to assault them, because they mistakenly believe that once you've consented to one form of sexual activity, you're consenting to all forms of sexual activity with all people, which is of course extremely wrong. And when it comes to disabled students, There are a couple of reasons. One is that a lot of people hold this very wrong belief that nobody wants to rape a disabled person, or nobody wants to have sex with a disabled person. And so if they're reporting it, they must be making it up, which is, really awful, because actually disabled people are 3 times more likely than non-disabled people to experience any form of abuse, whether that's physical or sexual abuse. And they often have, in some cases, they have more difficulty communicating that abuse, particularly if their abuser is their caregiver, or if they have a communication disability that makes it hard for them to talk about what happened to them. And so what we try to do is to really center all of these experiences and remind people that when they're addressing, when schools are addressing sexual harassment, that they need to keep in mind all of these different experiences and the ways that these stereotypes can come into play to harm women and girls of color, queer and trans students, and disabled students, and pregnant parenting students, so that they do not punish people for coming forward to ask for help. And we have a number of toolkits and reports that actually center these groups. Most of them are actually more focused on K-12 students, but we can drop them in the chat if you want to take a look. We have some reports on dress codes, on mental health, on discipline, as well as a fact sheet on survivor justice and disability justice.
Absolutely. Thank you so much, Elizabeth. And I'm going to switch up order a little bit so we can hear from Harjeet. I'd love to know from your perspective as well, working at Equal Rights Advocates, and just with your backgrounds, how you incorporate centering the margins in your work.
Oh, absolutely. And we definitely, Equal Rights Advocates definitely agrees with what Elizabeth just said, and just kind of building off that. For us, it's really about centering the voices of survivors, especially in marginalized communities, and also understanding that people of color have a unique and personal challenge in the Title IX process when it comes to even just discussing sexual assault. There's this cultural lens that is also something that students navigate and have to navigate through practically. And in many communities, these discussions are taboo. So it adds another layer of trauma that students experience and have to weed through. So we have many clients who come to us and are, navigating the Title IX process that may not even have told their families yet because of these kind of cultural barriers and how rare these discussions around sexual assault are within specific communities. So we try to focus on providing holistic, well-rounded services, and then also making sure that our services are trauma-informed. While the Title IX process is an administrative proceeding and each school has their specific Title IX policy, it's applied very differently in individual cases, and navigating that for individual communities can look very different. So as an example, I work a lot with South Asian students personally, and many times, the family situations don't know that the student has been raped or assaulted, and we're kind of bridging that gap between the student and the family to kind of breach these discussions. And I think that's an important piece of that, and another important piece that schools don't really consider as they navigate through these processes. I wanted to just pass to Brenda too, to make sure I'm not missing a piece here.
Yeah, absolutely.
Thanks. Yeah, really quick, agree with everything that's been said. The only thing I would add is that in addition to being, having increased rates of incidents and increased barriers to seeking help, there are fewer resources, significantly fewer resources. And so I think that's, one of the reasons why all of us here do absolutely prioritize helping folks who are experiencing these issues at the margins, because we want to make space and make sure that we are a resource for those people. So that's all I wanted to add. And I know Shawali had one thing to add as well.
Absolutely.
Thank you. And absolutely, all of this is very important. And I think, kind of recognizing what everyone has said so far about this, in incorporating or in centering the margins in our work, it also means thinking about policy solutions that don't further victimize or deter reporting from students from historically marginalized backgrounds. So for example, to the point that Elizabeth raised earlier about how students with disabilities or LGBTQ students or students of color, and in particular Black girls, are often not met with adequate responses when they report because of stereotypes and biases that are often, that a lot of school administrators hold when they respond to sexual assault, that then it's important for schools to ensure that they have adequate trainings for school employees on not only rape myths and stereotypes when it comes to sexual harassment, but also related to other forms of discrimination and how it impacts how they view other student survivors. And this also means thinking about other policy solutions that could impact reporting. So for example, at NWLC, we are against mandatory referrals of harassment complaints to law enforcement because the fear of interacting with police can be especially pronounced for students who are Black, Latinx, Muslim, immigrants, LGBTQ students, and students with disabilities. So we stress that it's important to think of ways that schools are complying with Title IX and responding appropriately while not responding in a way that would push students into another process that could further harm them or criminalize them and deter their reporting ultimately.
Absolutely, absolutely. Especially because we know with students who are at the intersection of their identities, that in and of itself is a barrier, when we're thinking about what type of society we live in under, white supremacy, patriarchy, misogyny, like all of the isms that we can think about. And, another barrier for us to talk about too is the cost, right? And so we know the National Sexual Violence Resource Center stated that from the CDC has estimated that the cost of rape is to be $122,461 per victim in their lifetime. And additionally, this has been estimated, there's an estimated of like 25 million who have been reported adult victims of rape in the US, which has equated to roughly $3.1 trillion. So why do you think this cost is so high? Like, what are the barriers that students are facing, especially when they're not only seeking legal support, but maybe even, or flip that, when they're seeking mental health support, physical health services, access to housing and education, but then, even on top of that, maybe some legal support if they decide to go that route. And Shwalia, I would love to start with you.
Yeah, I mean, the costs are extremely high. And, I appreciate, Kenyara, that you're raising this as an issue because it's something we don't talk about enough. And this is one of the many reasons why addressing sexual harassment in schools is a civil rights issue because of the harm that it causes to survivors of sexual harassment, including sexual assault and other forms of sexual violence, is that it impacts their access to education. And oftentimes that has a financial component to it. So for example, there are costs associated with having to, go through counseling to deal with the trauma from the aftermath of the assault. And unfortunately, many schools are not providing counseling free of charge when they should be as an accommodation to survivors because they need it to feel safe on campus or to learn or to continue their education. That's a cost. There are survivors who have lost scholarships or financial aid that's connected to their maintenance of certain grade point averages. And again, because of the harassment, it's, we've heard from many students who struggled focusing or staying in class because their schools didn't remove their rapists from their class or didn't provide them with extensions on homework exams or other accommodations they need to be able to succeed in their classes. So there's a cost with that. Or students who have just decided they can't enroll in school for the semester and they need to re-enroll later. There is some lost tuition that's associated with that unfortunately schools have not been reimbursing survivors for. And then of course the loss that comes to income based on loss of education through experiencing sexual harassment. So for survivors, a huge issue is being pushed out of school when students are not responding appropriately to their trauma or what happened to them. This could also include not graduating with a degree or having a delay in graduating from school, which impacts employment opportunities later on, which has an impact on salary. So there are a lot of consequences financially. These are just a few that I've named, but I think it's so critical that we think about this because we often don't when we discuss sexual harassment.
Yeah, absolutely. And Brenda, if there's anything you want to add here.
Yeah, I mean, everything that Shwali said is absolutely true. I think some additional costs can, in addition to therapy, there are actual medical costs that are often associated. Trauma causes a lot of physical, as we all know, everything's connected, right? So a lot of emotional and mental issues can translate into physical problems that people then need to seek treatment for. I have a client who, like Shwali said, was unable to maintain her grade point average. I mean, this is like a 4.0 student, and she was unable to maintain her grade point average and her scholarship as a result of being raped. And so she ended up having to take courses over the summer, which she did not receive a scholarship for, so she had to pay tuition money. She no longer received the free housing that they were providing for her, so she had to pay for her own housing over the summer. So housing can be another significant cost. And like Shwali said, I think a lot of this is delayed income. I think what's not reflected in these numbers is the emotional toll, which is extremely difficult to capture in a monetary amount. I mean, it's what we do when we sue people for money, is we try to say, well, here's the amount that this person should be paid. But as we all know, I mean, money can make things better in some ways. It can help a lot with certain things, but it will never, ever erase the trauma, not only of having been assaulted, but the secondary trauma, which we refer to as institutional betrayal and institutional trauma, that results when the institution that you trust, that you believe is there to protect you and to help you, betrays you because they don't believe you, or they treat you like now you're the problem for some reason, or they don't help you when you need help. And so all of that, and you should all really look into this because it's Jennifer Fried is the professor who's coined this term, and she's brilliant. And basically, what every single one of my clients has said, and this is true, every single one of them has said to me that they could have recovered from the initial assault or whatever the incident was. That is something they could have moved past or gotten through, if not for the way they were treated by their school, that it was the school's treatment of them throughout the process that made the whole thing worse. And what Jennifer Fried says is that not only does the harm from the school prevent you from recovering from the initial harm, it actually stops you from being able to heal from that. It also causes an entirely new trauma that you now have to deal with and heal from. So none of these numbers is capturing the impact of that on individuals.
Absolutely, especially when we're talking about the fact that I believe it's over 50% of students encounter institutional betrayal. And a lot of students I've also spoken with have said the same thing, in terms of their own healing journeys, that, I could have gotten, not over necessarily the trauma of my perpetrator, but it didn't help that my school also essentially portrayed me and violated me. So absolutely. And Harjeet, I know there's a few points you want to make as well.
Absolutely. So a lot of students that are in this process too also are here on student visas. Mm-hmm. And we see, especially a few of the clients I'm working with currently, they're still dealing with the trauma, dealing with the PTSD, and they need to take time off. And while you're taking that time off, a lot of them lose their student visa status. So now you're looking at immigration consequences. You're looking at consequences to entire families abroad. And then there's also this layer of kind of social media harm that kind of cuts both ways. One, in shaming students when people come forward and speak out, and then also this kind of really almost punitive way that respondents are responding to some of the students that do speak out, even anonymously, by filing defamation lawsuits and using that as a silencing and kind of chilling mechanism so that students can't even not only tell their story, but seek justice and seek strength in sharing their voice, which I think is a harm that is not accounted for either.
Mm-hmm. Absolutely. Elizabeth?
Yeah, 100% agree with everything that's been said. I wanted to add two quick things. One is that, you know, university health services are often not effective in treating survivors and helping them actually heal. And so, you know, we talk about supportive measures and the importance of mental health counseling and therapy to address the trauma, but there are so many survivors who reach out to, you know, UHS or CAPS or whatever the acronym is, and the people that they talk to actually can be victim blaming, can actually further the institutional betrayal that Brenda was talking about because they're not supportive. And so it's really important that just because there, you know, is that supportive measure that's being offered, it has to be actually effective and not exacerbate the trauma. And then the other thing I wanted to add is, you know, we talked about a lot of different types of ways that a lot of the different economic impacts of sexual assault and harassment, about tuition and GPA and housing and all of that, and future and lost income. One other thing I wanted to add is, of course, when you have loss of education or a lower paying job, it also means that it's harder to pay off student loans. And oftentimes survivors who are pushed out of school are still strapped with those loans. So now they're stuck, you know, in a position where they don't have a degree, but they still have to keep paying for it. And so not only are they facing that issue, they're also not making enough money necessarily to afford for the services that can actually help them heal, like counseling or therapy or safe housing as they continue to, you know, as they live their lives.
Absolutely, absolutely. And before we transition into the scenario part, I did get a question from the audience that I think is important to ask here. And the question is, can you please comment on restorative justice as an alternative to the regular Title IX process? I know that some Black African-American advocates argue for RJ because it addresses many Black women's hesitation about reporting on a Black man's assault when the accused is a Black man. On the other hand, I'm concerned that schools may pressure students into RJ because it's cheaper and means that they will not have to fear facing a lawsuit from a perpetrator found responsible. And if we can have maybe one or two under like 2 minutes, probably.
Yeah, I mean, I'd love, sure. And I know others on this call will want to. Yeah, I'd love to address that. Thank you, Bernadette. For your question and for the recognition of the hesitation that you mentioned, which we see all the time. For one, I want to start by saying one thing, which is that in my experience, the Title IX process as it is currently designed and implemented is not one that well achieves the goals of most of my clients. I think most people at the end of the day find that the process actually didn't get them what they wanted, which is why we start with an important conversation about what our clients' goals are. And then my effort is to achieve those goals. And it may not be fulfilling the entire Title IX process, right? And so you can enter into something that's called an early resolution agreement, which is absolutely not for everyone. Some people really want to go through the full process. They want to have a hearing. They want to have their moment to say whatever it is they wanted to say, their experience, and they want to see the respondent held accountable. Now, that doesn't always happen the way you think it will, but when it does, sometimes that is, you know, what people want. But in a lot of cases, I find that's not true. And so engaging in the early resolution process is a great idea for a lot of people because you can shape what you want. You can say, okay, here are all my demands, things that I can't get out of the typical Title IX process, right? Like, for example, you can ask that the respondent agree to attend individual therapy or a batterer's intervention course or some other course that's, you know, geared towards behavior and adjusting their behavior. One thing that gets at the question that you were talking about that we actually did in a recent case, because we were negotiating actually on the day of the hearing, and where we landed was our client really didn't want to go through the hearing process. It was very grueling and she didn't want to be, you know, aggressively cross-examined. But what she did want to do was have the respondent hear what she had to say. And so what we actually negotiated was kind of similar to an RJ situation where all of her statements and the statements of her witnesses were read to the respondent by the Title IX coordinator. So he had to sit there and listen to the whole entire thing. And it wasn't directly read by the victim and her witnesses, but the point was still made, and it still accomplished something similar for that person. A lot of those types of things that happen in person are really not appropriate for sexual violence cases, because it can be really triggering and harmful to actually sit in that scenario with your assailant. For some people, that is okay. Sorry, that was longer than 2 minutes.
You're fine, Brenda. Go ahead, Elizabeth.
Yeah, I wanted to add a few more things. Thank you for that question about restorative justice. I think, the difficulty of implementing one of the many difficulties, one, of course, you need to have well-trained facilitators and all of that. But I think one of the difficulties of implementing RJ is that, the first step really is to have the person who caused the harm acknowledge that harm occurred. That is the very first step. They have to consent to be part of this restorative process. And so if people are not willing to admit that they did cause harm, then that process cannot start, even if, the victim would like for that to be the process to be used. And so I think that's one thing that's important to remember. Restorative processes cannot completely replace an investigation unless all parties consent to it. And then just to go over some quick things so that we all are on the same page about it, when the victim and the person who caused the harm come together, the whole point of this is for the victim's needs to be centered and for the wrongdoer to acknowledge the harm that they caused and to create a plan to repair the harm that they caused. And so this is different from other types of informal resolution, like a mediation or a conflict resolution, where maybe both sides are required to reach a compromise. Because in this case, one person experienced the harm and one person caused the harm, and there's not a need, there should not be a process where the two sides have to come to some sort of compromise or to have any sort of blame be placed on the victim. So that's important as well. I think, I think that we all on this panel probably agree that restorative justice is an excellent option and that all schools should be offering it as long as, the facilitators are well trained and able to facilitate this in a, trauma-informed way. One other thing to keep in mind, of course, though, is that a lot of schools are doing mediation or peer conflict resolution and calling it restorative justice when it's actually not restorative justice, when it's not victim-centered, when it continues to be victim blaming, when victims continue to feel coerced into agreeing to something that they don't want to be a part of. They might even be coerced into the process altogether, as opposed to, they might be pushed from an investigation into that process. So these are a lot of different issues that we want to make sure don't come up. And then finally, I think I just want to add one more thing, which is that restorative justice is a little bit different from transformative justice in the sense that restorative justice is really about the two parties or the multiple parties that were involved in the incident, in the harm. And transformative justice is looking at the broader picture and thinking about what are the systemic conditions that were in place that allowed the harm to occur, and how can we transform those conditions so that the harm would not have occurred at all in the first place. So a lot of times people use those two words sort of interchangeably, but they're a little bit different from each other. And so that's important to keep in mind as well. But TJ obviously is a much bigger process because you're thinking about systemic change. And when it comes to restorative justice, sometimes what can happen is when people combine those two pieces together, restorative and transformative justice, and they don't do it in a careful way, what can happen is the needs of the victim can be sacrificed to the larger needs of the community. And it can then, what can happen then is that people pursue the systemic change more than they pursue reparations and restoration for the survivor. So that's another pitfall to keep in mind as folks think about doing restorative justice for sexual misconduct.
Thank you so much, Elizabeth and Brenda. I am now going to transition us into a few scenarios. As you all may still have questions in mind, please feel free to put them in the Q&A section. And while we're doing the scenarios, our panelists here can definitely answer those within the Q&A box itself. And so again, I want to provide a trigger warning to all of those who are attending this session for us, since the content includes sexual violence, sexual harassment, or assault, and possibly even suicide. Please note that all names, schools, and identifying information are fictional and have changed, but the story is real. And I also want to share that these individuals have received support. And as I share these scenarios, please feel free, for you all on the panel to share, about your programs regarding Enough and the Legal Network program. And so the first scenario is Julie Johnson is a senior with a full scholarship at Revolution University located in Georgia. Julie identifies as a student of color with an invisible disability. Preferred pronouns are she, her, hers. And at the start of the academic year, she began a romantic relationship with her professor, Will Woodbridge, who is well known not only at RU, but throughout the state for musical contributions in the music industry. His wife, Rhonda, also works at RU as her work-study supervisor. Julie has tried multiple times to end the relationship with Will, yet has threatened to get her scholarship removed, and that if she were to tell anyone, he would, quote, use all of his power, end quote, to get her kicked out of school. Julie decided to report this to her Title IX office and provided them with all of the evidence of his manipulation, including recordings of conversations, text messages, and emails. The Title IX coordinator gave her 24 hours to respond to their initial communication in order to proceed. So based with this information that I just shared with you all, Harjeet, I'd love for you to share about how you would approach this case and what should the student know and what are the possible outcomes that the student would possibly have?
Absolutely. I think the most important thing that it's really, really important to bring on legal counsel as early on in the process. And that sometimes is even before you file a formal complaint. At ERA, we have an advice and counseling line where many students wait until there's a hearing in place or the investigation has completed before they contact, because one, they don't know that we can help with the actual filing of the complaint or that there's accommodations that can be made early on in the process. So the first thing is to make sure students come on early and invite counsel into this process. And then there are a myriad of accommodations that can be asked for to preserve scholarships and even preserve access to justice. A lot of time, and access to education, a lot of times students will drop out of school while they're going through this process because they don't know that these accommodations can be made, whether it be removing certain people as advisors or removing that student from a situation where she would be in classrooms around his wife or around this professor, and providing accommodations around that, and then also requesting no contact orders with the parties that are involved, as well as just adjusting to student life on campus in a way where the timings can be adjusted within the departments as well, where the student doesn't have to be around people that now they're in this Title IX process with. And then I think a major issue in this scenario is the invisible disability. So there's this 24-hour time to respond, but you can also ask for an extension and also say, look, the student has this disability, which will make it exponentially harder to deal with trauma. And that's a reasonable request to make, that, hey, that 24-hour response time isn't going to work. Mm-hmm. And then just really taking into account as well the power dynamics here. An investigation sometimes is something that's rushed through and without legal counsel to take account for, this also being a professor and then also having the professor's wife as, the work study supervisor. There's Title VII crossovers here as well. So I think all of that would need to be taken into account. And in terms of possible outcomes, I think I'm going to partner with Brenda on this one so she can elaborate on that end.
Absolutely.
I have a dog barking in the background. I'm so sorry. The one thing I just want to add is, is that there are often very tight deadlines in these cases, and I just want to encourage everyone to tell everyone these deadlines are made up. You need to push back. And with attorneys, it's really easy to do that. We do that for you. But I just want you to encourage everyone just because a school says you have to do something within 24 hours doesn't mean you have to. It feels like that because your school's telling you that, but there's no rule that says, you know, no law that says you have to do that. So when you need extra time, I encourage you to ask for it, because it's I'm so sorry, she's going insane. It's just really difficult to meet those deadlines, and it's not necessary.
Absolutely. Thank you both so much on that. I'm gonna ask one more final scenario just due to time here, and share that, you know, again, if anyone has any questions, please feel free to put them in the Q&A, and Brenda, Elizabeth, Shwali, Harjeet would certainly be able to answer those for you. So the second scenario is Antonio Armes is a graduate student who attends the University of Legacy, and they are attending on a temporary visa. Their pronouns are he, him, his, and identify within the LGBT community. In late fall of the academic year, they filed a Title IX complaint with Legacy's Title IX office about how they were sexually assaulted by another graduate student 1 year prior. Antonio was kicked out of school, and their visa at their school was denied. This means he will not be able to graduate this year, and he is fearful of being deported and doesn't have family to rely on, and is encountering suicidal ideation because of what is happening. Based off this information that I've shared, Shwali, you know, how would you approach this case?
First off, it's important to know that Antonio still has protections under Title IX, and the school should be providing Antonio with supportive measures and accommodations to have prevented exactly what have happened, which is, you know, Antonio being kicked out of school and now dealing with suicidal ideation and the fear of deportation. So they should have responded much differently. And also what they've done, you know, I would ask, is this retaliation? Because if he's being retaliated against for exercising his rights under Title IX, then that's also a violation of Title IX. So that's concerning as well. And then the other issue, and you know, I'm not an immigration expert here, but there are options if the visa has expired, like there are U visas for victims of crime, which does require cooperation with law enforcement. But that allows for someone who is a victim of crime to be able to apply for a visa if they don't have status, so long as they cooperate. So again, I think that would warrant a discussion with someone who has more experience in immigration matters, but there are various options that are available. And you know, this scenario seems very concerning that the school, like, they didn't fulfill their Title IX rights to respond and to provide supportive measures and accommodations, and B, they retaliated against him. That's what it seems like from this scenario.
Absolutely. I think we may have time to do this last one in 3 minutes if we can, just because I think it's important in terms of the intersectional pieces here. So I'm just gonna say it. Kendra King, a Black transgender student, attends RU Resilient University. Pronouns are she, her, hers, and she has a current Title IX case for the past 11 months. And RU hired a lawyer for her assailants and other students, and the lawyer cross-examined her without providing her with a choice or means to do the same. There have been other students who have been hurt by the same perpetrator, yet have been either paid off by the school, i.e. their school tuition has been paid, or forced to take a leave of absence. And she would like to pursue criminal justice outside of school since the school hasn't fulfilled their obligations under Title IX. And the school also decided to move her case from Title IX level to student misconduct. She was told that she's too, quote unquote, high functioning, end quote, and that there isn't anything that can be done by the school. Harjeet, I wanna give that one to you as well.
Yeah. I mean, I think this is a very important, and it's also something that we see a lot in terms of just patterns within schools. So that being said, I think sometimes when we look at Title IX, we think it's a process that is solo, but it's not. You can have parallel legal proceedings in other realms as well. So this would be something that I think we would consider a high impact kind of litigation type case as well, where you can bring a civil suit. You could also file with OCR. It sounds like there's other policy issues within the university in terms of where they're forcing students to take leaves, or, you know, instead of changing policies and procedures on campus, it's really on each individual student to kind of navigate through this process where it seems like there's a systemic issue here as well. And then I think it's really important in this scenario too, that, you know, this issue of the lawyer cross-examining her without providing her with the choice or a means to do the same, that's a violation of their Title IX rights. And that's something that is right for the student to be able to appeal. And I think these issues are really critical, and it's something that, again, that's why we need attorneys involved in this process so that we can help identify these issues. And then, you know, just the demographic profile of the student too, being a person of color, being transgender, you're already, you know, part of this marginalized community that is more vulnerable to these issues, and also more vulnerable to, frankly, not being treated right within the Title IX process itself. I think it's easier to push students out when it becomes like this demographic. And I think sometimes students hesitate to take on a university and say it that frankly. But, you know, there are issues of systemic racism. There are issues of, you know, gender inequality when it comes to transgender communities within access to education and how university policies treat those students. So those are just really a few things that pop out to me. I know other folks want to talk, so I'm gonna pop over.
Absolutely. And I just want to mention, you know, we're speaking to attorneys who have very busy schedules. And so you may have seen Shwali hop off a bit, and that's just because she had another meeting to attend to. And so with respect to time and with respect to everyone else's time, I do want to, you know, provide you the space and share any final words that you have before we conclude our session.
Yeah. I can just say two quick things about that example. I think the phrase high functioning is really problematic, and I wanted to point that out. High functioning is something that is a phrase that people will use to talk about disability, for example, autism. It could also be a general sex stereotype about how survivors are supposed to act after an assault and what a real victim looks like. So it's not clear like what the school is trying to say here when they say that the survivor is too high functioning, so that's why they can't help her. It could be disability, it could be sex, it could be both. But whether it's a disability stereotype or a sex stereotype, it's unacceptable. So I wanted to point that out. And the other thing, you know, the scenario mentioned that Kenda is thinking about going to the criminal legal system because the school isn't able to help her. And I think it's important to raise here that the criminal legal system is likely not to help her get what she wants, which is supportive measures. What I think, you know, survivors want is to have access to education, to stay in school. And unfortunately, the criminal legal system is extremely biased. I don't need to tell anybody this, but they're extremely biased against Black people and trans people. And so as a Black trans woman, they're unlikely to, you know, assist her. They're likely to be very biased against her, disbelieve her, possibly sexually harass her in the process of taking her, you know, intake. And it's quite difficult to prove that beyond a reasonable doubt standard that we talked about earlier. And so, and even at the end of the day, even going to the criminal legal system is only going to result in incarceration for the person who harmed her, but it doesn't give her anything in terms of what she needs to stay in school and succeed. And so, you know, it's understandable why she might be thinking about going to the criminal legal system because her school is not supporting her. But it's important to keep in mind these realities. And of course, this is also why it's so extremely important for schools to have proper Title IX processes, whether that is an investigation or a restorative process, or other means of helping survivors, particularly survivors who are the least likely to be helped by the criminal legal system.
Absolutely. And Brenda?
The only thing I will add to what Elizabeth said is that less than 2% of sexual assault crimes are prosecuted. So whether it would, and I agree with everything Elizabeth said, and it just probably isn't going to happen. So it's probably just going to be another incident of this person experiencing you know, trauma from having been rejected and turned away and, you know, not being believed or not thinking that what they experienced is important. So It's everyone's right to pursue criminal justice, but for all the reasons that Elizabeth said, I think it's probably not going to help this person. And I just wanted to close by saying thank you so much for having us. And I know that we will all welcome any additional questions or follow-up to our email. So hopefully Kenyora can provide that to you and you can reach out to us. And I encourage you to look at our websites. Both of our organizations have lots of guides and self-help tools. And ERA is actually putting together a survivor toolkit that we'll be coming out with shortly. So we encourage you to visit our websites for more information.
Absolutely.
And I just wanted to pop in real quick. For all the attorneys that may be attending, I did want to say that we're always constantly recruiting for our pro bono network. I apologize, there's noise in the background. But we're always constantly recruiting for the pro bono network to add attorneys to take on Title IX cases. So if you're interested, I'll put my email in the chat. Please do reach out. Our students need you.
Absolutely. Thank you so much, Harjeet, Elizabeth, Brenda, Shwali, truly for your time and your expertise on this very important information that you have shared with myself and with our attendees. Truly, you all are instrumental partners for NREEF on campus, and I am so much indebted to you, and especially with all the support and advice you have provided for me as well. And so for that, I definitely just want to say, a very big thank you. And for those of you who are watching, we will have this recording made available for you on our Facebook, as well as on our YouTube with closed captions. And so that will be provided for you in the coming days. Actually, really within 24 hours, it's that easy. And so thank you so much for attending our session this afternoon, this morning, and please stay on the lookout for more of our Centering the Margins events for this month. You can go to bit.ly /EROC, that's in all caps, and all caps CTM. So thank you again, and please take care of yourselves and have a wonderful, wonderful rest of your Wednesday. Thank you.